everyone. My name is John Osa. It's my pleasure to be the moderator of this session. Xavier, you've appeared on the screen, and please go ahead.
Yes, thank you, John. Good afternoon to everybody. It's a real pleasure to participate to this WIPO AIPPI webinar, and I've been asked to give you an outlook about the work of the Advisory Committee on Enforcement, the ACE, to use the English acronym, and also on specific WIPO initiative, which is the WIPO Alert Database. So please allow me to just get into my presentation. Just a second. All right. All right, the system is loading. All right, so here we are. So the Advisory Committee on Enforcement is the WIPO's committee of member states, serving as the forum for policy dialogue on questions of IP enforcement and, more broadly, building respect for IP. As the name indicates, it's an advisory committee. So in other words, there is no norm-setting work which is being performed within this committee, since there is simply another body for that, the Council for TRIPS, in the ambit of the World Trade Organization. But the advisory nature of the ACE facilitates the dialogue between the member states on experiences and practices in the field, because in a way there is no fear of any judgmental view by other member states when one member state presents its practice and experience in the field. The ACE is a forum for member states, as I said, but there are, of course, observers from the public and the private sector, including, of course, AIPPI. Now, we observe, actually, a growing interest for the work of the ACE, both with member states and among the observers. You have on this slide the indication of the outfit of the last ACE session that took place in September of last year. Important to bear in mind, all the work which is being done in the ACE is based on written documents, and those written documents are publicly available. You have the AIPPI link there, so there is a lot of information available in the 6 official languages of WIPO. As I said, we observe a growing interest among both the member states and the observers. You'll see here the graphics relating to the rate of participation throughout the ACE sessions. Now, the thing is that for some time now, since the 11th session of the ACE, there are 4 main topics which are being discussed in the ACE. In other words, 4 topics to which the member states of WIPO wanted to dedicate the time for the discussions within the ACE. First and foremost, there is the question of the awareness raising. That's important, raise the awareness of the public to ensure that they participate fully to a culture of building respect for IP. There is also the legislative assistance and the capacity building activities which are being provided by WIPO in the field of enforcement. And you see the topic institutional arrangements concerning IP enforcement and balanced, holistic and effective IP dispute resolution. A very broad topic, obviously, but that allows a lot of discussion between the member states on topical issues relating to IP enforcement. For example, in the last year, we discussed within this framework the coordination of IP enforcement, the coordination between the various stakeholders on IP enforcement, and we had contribution from Greece, Morocco, Brazil, the Republic of Korea, the USA, Spain. We discussed also new technologies on IP enforcement, with presentation by Switzerland and EU. Certainly of relevance for you all, a study authored by Professor Mustard and Barrister Jane Lambert was presented, a study on IP enforcement measures and especially anti-piracy measures in the digital environment. So this study is of course available for you to read. We discussed arrangements to address online IP infringements, the role of intermediaries on IP enforcement issues, with presentations by the Universal Postal Union, Alibaba, Amazon, Facebook, Google, etc. And also a presentation on judicial and prosecutorial discretion in IP infringement proceedings, including a contribution by Judge Hart of the IP Enterprise Court in the UK about exercising discretion to grant additional damages under the UK Copyright Designs and Patent Acts. So you can see you have a flavor of the topical issues that are being discussed within the framework of the ACE. So for the next session, if all goes well, it will be held in October of this year. And again, member states wanted to continue the dialogue on these issues. And so we will continue to discuss inter alia enforcement coordination, new technologies, online IP infringements, also the cross-border effects of judicial injunctions, and important, the issue of damages, because in this session of the ACE of 2018, actually, of course, we were aware that AIPPI made a study on the quantification of monetary relief that led to the Sydney resolution, and we invited AIPPI to participate in the 2018 session of the ACE, and AIPPI made a presentation. Now, this is of course very important, taking into account that the work you did in London relating to the issue of the damages for acts of infringement other than sales is complementary to the work done in Sydney. So it looks for us quite important to offer the opportunity of AIPPI, if AIPPI so wishes, to participate again in the next ACE session and make a presentation relating to the work done in London. So this is an open invitation to AIPPI. So this is in a nutshell what I wanted to say about the ACE. Now, there is something else I wanted to mention. In the ACE, we discussed also, for example, the infringing website list initiatives. And this is quite important, actually, because these are initiatives aimed at preventing paid advertising on copyright infringing websites. As you probably know, online advertising is a major source of revenue for online operators of copyright infringing websites. And, you know, due to the complexity and difficulty to control the system of selling online advertising, legitimate brands owners may find their advertising appearing on pirate websites. And hence, these brand owners unwillingly contribute to funding copyright infringing websites. And because of the presence of their brands on those websites, it confers an aspect of legitimacy to the pirate websites. And this, of course, is a problem, and it's a problem for the brand owners themselves, because in a way, when it appears that the website is copyright infringing, well, the mere fact that their brands appear on that website tarnish the reputation of their brands. So this is an issue, and in some member states of WIPO, they have developed this initiative of gathering information about copyright infringing websites. The gathering of this information is made by public authorities, and the public authorities share this information with the advertising industry, enabling the advertising intermediaries to avoid placing or continuing placing ads on these websites. A well-known example is the UK initiative led by AIPPI, the Police IP crime unit of the City of London, which maintains such an infringing website list and put it at the disposal of the advertising industry. Other member states have developed similar infringing website lists initiatives, and still other public authorities are involved in the blocking of pirate websites, such as the Italian AGCOM, the Italian Communications Regulatory Authority. What implies, of course, if we want to block a website, that implies that you have collected information about the targeted infringing websites. These initiatives were presented in a previous ACE session, but of course those initiatives are national, and that's where WIPO, in consultation with the member states, thought about developing an international initiative, which led to the WIPO alert database, which was also presented in the last ACE session. So what is it all about? It's basically the idea of gathering, of compiling the national list of copyright infringing websites, and to put that in a secure online platform to which agencies the lists are uploaded by the national agencies, and these agencies are so-called authorized contributors, if you can see on that slide, and approved actors, authorized users of the advertising industry would be allowed to get access to this database, and in order to inform their decision on whether to place or not advertisements on specific websites. So in other words, the idea is to have an international compilation of the national list of infringing websites in order to facilitate things, also for the users, because you would have a kind of one-stop shop, if I may say so. So it is very important to understand how it works. And here again, this is something very important. The member states keep the control of the database, in the sense that the contributors retain the discretion as to the disclosure of their lists on this WIPO platform, and they decide which users can have access to their lists. So this is something very, very important. It is envisaged that later on the contributors will also provide a description of their process in identifying infringing websites, and that information will be provided to the public. So it is important also to bear in mind that the respect for due process is assured by the member states. The responsibility of the list remains with member states, and WIPO just compiles this information on this database. So that is the way it works. Perhaps just briefly, if you see this slide again, so the way it works, there is a letter of understanding between the contributors, meaning the public authorities, getting these lists of IP infringing websites and uploading it on the WIPO platform. And there is a user agreement between WIPO and the user who wish to get access to this platform. Again, access is provided insofar as the contributors agree with this request. So that is the way it is being performed. So the WIPO alert is something being currently developed. We are really in the first weeks of performance of the system. You can see on the slides the current contributors and the current users. Of course, negotiations are ongoing. We hope for more collaboration and more stakeholders taking part to this system. More information will be provided, I speak in the future, on wipo.int/alert. For the moment, if you go there, there is no information, but later on, more information will be provided for the general public to know how the system works. But again, if you are interested by this WIPO alert database, I certainly invite you to read the document which was presented in the last ACE session. Okay, that was in a nutshell what I wanted to present. I thank you for your attention, and I give the floor back to you, John.
Xavier, thank you very much for that excellent summary of your work, and thanks for all that you're doing on behalf of enforcement worldwide. Thanks also for mentioning AIPPI's resolutions, the initial resolution from Sydney, which related to quantification of damages, and then the more the resolution from last year in London, which dealt with damages for acts other than sales. And indeed, as you mentioned, I think these are very, very useful studies. From the standpoint of respect for IP and public policy, it seems logical that fear of paying damages discourages infringement and thus would enhance respect for IP, one would think. At the same time, though, if one could potentially obtain damages at each stage of, say, manufacturing, importing, warehousing, etc., in addition to sales, this might be viewed by the public as abusive and might even backfire in terms of respect for IP in the eyes of the public at large. So in this age where respect for IP is already tenuous in some circles, what do you see as the proper balance of enforcement as a deterrent to infringement and reasonableness to help engender respect for the IP system overall?
Well, that's thank you for this question, John. It's quite a very broad question, and I could develop that for hours, not just for in a few minutes. So I will try to get to the core of the matter. First, as to the damages themselves, of course, the benchmark is the principle enshrined in Article 45 of the TRIPS agreement, which is that it is needed to compensate the prejudice suffered by the right holder and compensating him or her wholly, but not more than that, notwithstanding the issue of civil sanctions or treble damages, which might apply in some jurisdictions. In some determined cases, the principle of fair and entire compensation is the cornerstone of the civil remedy of damages, both in civil law and common law countries, right? And I note, by the way, that in the London resolution of AIPPI itself, works is being made on this premise, basically, because there is a call for the avoidance of double recovery, all right? That's for the damages. Nevertheless, it's still difficult to determine what is the right balance, you know, and that's precisely one of the major difficulty of the work you have done with the London study. Now, from a broader perspective, you are right in considering that the challenge is to find the right balance between a sound system of IP enforcement as a deterrent to IP infringements without creating an anti-IP feeling. And by the way, this is directly in line with one of the WIPO strategic objectives, which is to foster international cooperation to build a sustainable environment of respect for IP. And of course, we all agree that IP enforcement in itself is essential to ensure the reliability of the system of IP protection. Without an effective IP enforcement system, well, IP protection would just be an empty shell, failing to encourage innovation, creation, and dynamism in the markets. And that's, of course, we all agree with that, the rationale of the IP enforcement as enshrined in Part 3 of the TRIPS agreement. But of course, abuses of enforcement procedures or even a blind implementation of civil measures and remedies, or where applicable, criminal procedures and sanctions without taking properly into account the circumstances could have a detrimental effect. So how to deal with that and how to progress towards a sustainable culture of respect for IP more generally? Well, to start with, it has to be recalled that a sound and efficient IP enforcement system is only a part of the strategy to build respect for IP. It must be accompanied by other strategic elements. It is also important to work on preventive measures, not to work only on the enforcement side and on the side of the demand for IP infringing goods. That implies working towards the awareness raising of the public. I mentioned in my presentation that that was one of the key topics being discussed within the framework of the ACE, and that's exactly at the request of the member states, because they do consider themselves that awareness raising is a key aspect in any strategy of building respect for IP. On the side of the offer of IP infringing goods now, it's important to work also on measures which are, I think, complementary to pure IP enforcement mechanisms. And this is best illustrated, I think, through soft law initiatives, the development of voluntary agreements between right holders and intermediaries, specifically in the online world, or initiatives such as the infringing website lists that I spoke about when I talk about WIPO alert. And all those kinds of initiatives and measures are, by the way, of course, also topics that member states brought forward in the discussions within the framework of the ACE. And then, of course, there are indeed the enforcement mechanisms themselves. And here, it's perhaps important to remember, to recall the word you use in your question, which is the word of balance. And this is a key point. After all, Article 7 of the TRIPS agreement, which is this provision which captures the philosophy of IP enforcement, calls for conceptualizing IP protection and IP enforcement in a balanced way between the various interests at stake, the interests of the right holders, of course, but also the interest of the users and the interest and the general interest at large. And this implies choices to be made by the lawmakers when they are implementing Part 3 of the TRIPS agreement and adapted to local circumstances. And I think in particular to the various options open to the member state of the World Trade Organization in the provisions of Part 3 of the TRIPS agreement. But this is only one aspect. Another aspect of balance appears through many of the provisions themselves of Part 3 of the TRIPS agreement when they call for the proportionality of the measures to be ordered by the civil or the criminal judge, or when they permit to order measures in appropriate cases. Often we see those terms, in appropriate cases, in the TRIPS agreement. And that is to say, the role of the judge in implementing IP enforcement measures, in ensuring the proportionality of the measures and the remedies, cannot be emphasized enough, I think. And I must add, if the judges have to ensure proportionality, of course, the role of the attorneys at law in the course of litigation when discussing measures to be ordered by the judge is also of key relevance. And so to sum up, there is, of course, no one-size-fits-all and a kind of magical approach as to how best to ensure the balance between enforcement measures and reasonableness to contribute to the culture of respect for IP. It is through the efforts of all the stakeholders, policymakers, lawmakers, law enforcement officials, judges, attorneys, right holders, working on the various aspects that I've mentioned, that progress towards building respect for IP could be achieved. Thank you.
Wonderful, thank you. We all have a lot of work to do, I think. I have a related question from one of our attendees who represents herself as the WFEO representative, and I think that's the World Federation of Engineering Organizations, if I'm correct. And she asks, how can NGOs such as hers and others working with the industry and in education help develop IPR in the developing world? We have a large network of engineers and scientists in all innovation areas and would like to contribute to fostering a sustainable IPR system.
Yes, so I guess this question relates more to the question of raising awareness through education in the developing world. A lot of initiatives are being taken also in WIPO and with the local partners. So I invite certainly the participant to look at the documents which have been presented within the last 8 sessions on this topic of awareness raising, and she will see a lot of initiatives which have been developed. And WIPO itself is, as I say, working a lot on those issues with local partners. Of course, it is important to avoid duplication of work. So I would certainly invite this participant to liaise with us further with our division, and we would discuss that further. But the point is the following point to be remember is this one. In the developing world, a lot of work is being done and a lot of initiatives are being developed to raise the awareness of the public. So it's certainly not just something for the developed world. A lot of work is being done in the developing world as well. So it's good if we can coordinate the efforts in that regard.
Great, well, thank you very much, Xavier. That was very interesting. And we all look forward to supporting you in your continuing work. And thanks for all that you do. It remains for me only to thank all of the speakers for this wonderful session. This really has been educational, informative, and enjoyable. The sun is now up in Idaho behind me, as you can see. So it's morning here. And again, I want to thank all of you and thank the participants. And Arno, I'll pass it over to you for any closing words.
Thank you very much, John. I also want to extend my thanks to all the speakers for their excellent presentations. It takes a lot of guts to speak in front of your computer home screen under the constant threat of you know, like wives, husbands, other family members or pets bursting into the room, and you managed brilliantly. This would be the time now to hand out flowers, but different from PCT filings, we're not yet in a position to send them electronically, but we will make sure that in the next few days, weeks, or probably even months, when you reach your office the next time, there will be a very small token of appreciation waiting for you. Thanks also for WIPO and in particular the NGO and industry relation team, Tom and Christopher, for making this possible. We're looking forward to additional editions of this format in the hopefully near future. And if you allow me to quickly address all those webinar participants who are not yet AIPPI members, and I was surprised there are actually a lot of them. Yeah, if you're interested in getting a member or becoming a member of AIPPI, please do get in touch with us. The fact that you stayed with us for 2 hours now, it indicates that you're interested in IP, and we're open to everybody interested in IP. So please contact us or contact our national groups in your destination country. Some of them offer very interesting membership discounts, and they would be happy to introduce you to our services what we offer to you. Yeah, finally, let me thank all the participants of this webinar, and please stay safe, but stay connected to your peers, and I hope we will no longer have to focus soon on protecting ourselves, but can continue to protect IP. Thank you very much on that note. Goodbye.